We heard from many lawyers who expressed their happiness that this program was being made, but they did not want to go on camera because they feared retribution from the bar. One of those lawyers agreed to go on camera, but only if we kept his identity a secret. We will call him Steve, which is not his real name.
I have a family member who is an attorney, and I do not want retribution or problems for that family member. And I have no doubt, at least in my mind, and I don't think I'm paranoid, but I have no doubt that there could be repercussions for this family member, and I don't think it's fair or right for this totally innocent person to suffer bias and prejudice or repercussions as a result of this interview.
Steve was a successful attorney who had practiced law for many years. Then one day he received a traffic ticket and later forgot to appear. A bench warrant was issued for his arrest. When he later appeared in court to take care of it, his nightmare began.
Unknown to me, the senior deputy DA, I found this out later through witnesses, flashed my name in large letters to the judge. Without anything being said, as I'm walking away from the bench, I have my back to the court. Two rather large bailiffs, certainly much larger than me, just pounced on me. And then in just a matter of seconds, 4 other bailiffs, so there were 6 bailiffs, as I recall, and they're all large guys. They slammed me up against the wall, the back of the court, and this was a small courtroom. They pummeled me, they hit me in the side, and they were punching me in the face and the neck. I was carrying a satchel that had legal papers. One person had their hand wrapped around my hand that was on the suitcase, and they kept saying, "Drop your suitcase." I couldn't open my hand. Meanwhile, they're pummeling me, hitting me left and right, saying I'm not cooperating. They were choking me. I couldn't breathe, and I was, yelling I was being choked. They choked me so viciously that they lifted me up with their hands on my neck, and I passed out for a couple seconds. According to witnesses who were there, I turned blue, and I fainted for a couple of seconds. So they have me in handcuffs. I'm in a suit and tie. They're walking me, pushing me, after beating me up and choking me, through the doors from the courtroom to the jail. One of the sheriffs that's on the side, there was a phalanx of sheriffs. He sticks his foot out, and I trip over it. They charged me 2 charges of resisting arrest. One of which was where the guy sticks his foot out and tripped me, and I fell on my face and almost broke my nose.
News of this reached the state bar. Instead of helping Steve as a trade guild might do, the bar filed disciplinary charges to take away his law license. The bar charged Steve with additional misconduct because 3 of his clients complained that he had dropped their cases. One involved a bankruptcy.
She had filed for bankruptcy, 6 or 7 years earlier, and she had fraudulently transferred her condominium to her daughter, who was a realtor. And her daughter would not give her the property back. And she wanted me to represent her in this fraudulent transfer, and I said I wouldn't do it. So she filed a complaint.
The second complaining client was similar.
She had applied for workers' compensation and Social Security disability in this state. And we tried to represent her on the workers' comp case and the disability case as Social Security disability. She then moves out to another state, and then tries to collect up there. And I said, well, we have to drop the California case because that's fraud. She immediately files a bar complaint saying I won't represent her, and of course lies about her attempted fraud.
The third client wanted Steve's help with an illegal scheme.
She comes to my office and she tells me how she had read something in one of these landlord-tenant books, and if you claim all these breaches of warranty of habitability, that you can win the case. And in other words, she was trying to perpetrate a fraud and had already done so and was continuing. I didn't know she had perpetrated a fraud earlier, but once she told me that, I said, no, I can't do that. I cannot legally. It's unethical and illegal for me to allow you to falsify evidence and say things that aren't true. And especially when you're telling me I can't do that. So she got irate. She literally came back a couple of weeks later, stormed into my office, threatened to kill me, and filed a bar complaint. Oh, she ended up taking this to the state HUD office in San Francisco. And they denied her all of her claims.
Having been a very experienced litigator, Steve says that he was dismayed at the conduct of the State Bar Prosecutor's Office, the Office of Chief Trial Counsel.
We as lawyers study due process. Well, there's really no due process, or very little due process at the State Bar. And it's almost, some of those people, it was almost as if they relished in flouting the rules. I had talked earlier in my case where I was taking depositions of people that filed complaints against me. The State Bar prosecutor appeared at those depositions, and he'd routinely tell them not to answer any questions. And he'd interrupt me constantly. And he'd tell the person, they don't have to answer that. You don't have to answer that. You don't have to answer that. And told the court reporter to literally stop the deposition as I was making points, so to speak. The State Bar raised no objections. They simply told the people repeatedly, don't answer that. And in two of the depositions that I tried to conduct, they simply sent the people home. They would not answer any discovery whatsoever. And of course, all this leads to the additional stress. Because as a lawyer, you know that what kind of, excuse the expression, BS they're pulling. You know, it's not like someone that doesn't know. You know what they're doing. They know you know what they're doing, and they're laughing, essentially. They don't care. They expect us to be ethical attorneys. They're the most unethical attorneys I've ever seen. When they do a write-up for your, quote, discipline, they need to actually negotiate this. There's no negotiation. It's my way or the highway. And some of the things that were said in mine and in talking to other people in their version of the facts by the State Bar are so incredibly incorrect that it turns your stomach to sign that. And in my case, you know, my heart went up to my throat, my stomach turned. I said, you know, these facts are wrong, and I just can't sign this. I'd rather, you know, just not go to trial. I would sign something if it was factually correct. You know, I didn't mind being suspended for a year or two. I was probably looking at 2 years. I didn't mind that so much, but just to sign these fraudulent factual statements, I mean, it was like he was using someone else, boilerplate or something. It was just, I couldn't bring myself to do it. It made me ill. So that led to the decision that I couldn't sign it, and then we went to trial.
As Steve's case wound its way through the State Bar Court, his experience with a State Bar judge was not much better.
Because I was trying to defend myself in the criminal resisting arrest, and I had to appear in court, the State Bar said I had to appear at the state bar, and it was the same date and time.
The judge abruptly suspended Steve's law license before the trial.
Come to find out, they suspended my license without any notice because I didn't appear, even though I gave them notice and said I have another matter. Another thing that was unfair, my attorney had an illness. To make a long story short, that illness had something to do with breaking one of the bones in his foot. So he ended up going to his local hospital. He had to get, pain medication, cast, that kind of thing. He asked for a very brief continuance. They refused to do it.
Nearly every discipline charge against him was dropped before trial, but the state bar still billed him for the entire prosecution. This was in addition to $30,000 in legal fees that Steve paid to a discipline defense lawyer. Meanwhile, I get accepted to this graduate school program. Again, I'm not going to name it, but I got accepted to that, and I said, wow, that would, be really interesting. I had a choice to make, either to do the graduate school program or to do something about the case. And by then I was worn out. So in a moment of weakness, we thought I would resign from the state bar.
But I know that there's a reign of terror, and it remains as a reality. Attorneys must be very careful.
Richard Canatella is a respected San Francisco attorney who has practiced law for nearly 40 years. He was disciplined in 1999 by the state bar and received a 30-day actual suspension, mostly as a result of cases in which he went up against large corporate law firms as a sole practitioner. Although many people would consider 30 days to be a light punishment, his experience left a strong impression on him. He continues to speak out today.
Well, around 1985, Rule 11 had been amended. That's Rule 11 of the Federal Rules of Civil Procedure. And the rule was amended to make it acceptable or permitted for federal judges to impose sanctions on attorneys, monetary sanctions, for, quote, frivolous actions. And I had at the time several cases with large firms, of rather prestigious firms, and the strategy to get my client and me would be to get sanctions, monetary sanctions. So I found myself defending a barrage of motions for monetary sanctions, and at least 2 federal judges agreed.
According to the state bar, Richard was sanctioned 37 times, which would have occurred over a period of more than a decade.
And the bar prosecuted me for those sanctions in I think it was 98. That's how I met my first encounter with the bar, and I paid over $100,000 in sanctions to the lawyers who got the orders. And it was devastating to me let alone economically. It was morally devastating because it labeled me as a loose cannon, incompetent, and related adjectives. The State Bar picked up a feature article in the San Francisco Recorder about me. The article was styled "Firing at Every Target in Sight." And the State Bar took that article and investigated me, and the whole proceeding against me was based on this article, this San Francisco Recorder feature article, essentially giving me a scarlet letter, if you will, for inappropriate attorney conduct. When the truth was, I was zealously representing my clients against very powerful, high-powered lawyers who, incidentally, would not have the likelihood of having happen to them what was happening to me at the time, because of the simple fact that the larger firms and the more prestigious lawyers are essentially accepted from the heavy sanctions awards that were coming down, or although there are exceptions, but for the most part, the targets of monetary sanctions at the time that I was receiving them were, if you will, small firm or solo practitioners. The reign of terror, if you will, stopped when Rule 11 was amended to allow for a due process protections. That is, an attorney would have an opportunity to respond to a sanctions motion.
Richard signed a stipulation with the State Bar prosecutors, admitting to many of their charges. Richard says that the stipulation was, in many respects, a false confession.
There was a stipulation, but there were certain issues in the stipulation, certain facts that were misreported. The number of sanctions, for example. I think I was reported as having 37 sanctions orders, and the truth was I had something like less than 25. And these covered a period of, I think, almost 12 years, which at the time would not have been inordinate because courts were looking for ways, if they surfaced, to sanction attorneys on a simple conclusion that the position that the attorney took was, quote, frivolous, on very complicated legal issues like res judicata and collateral estoppel and issues like that.
Richard explains why he signed the stipulation instead of fighting in State Bar Court.
For the most part, the Bar Court essentially, I believe, has an institutional bent to upholding whatever the prosecutors would want them to do.
Richard describes another pressure that many accused lawyers face in the discipline system.
With regard to these cost assessments, where they impose through the superior courts cost assessments and obtain final judgments for money damages that are very substantial. I'm talking about thousands and thousands of dollars. It would discourage any attorney to risk having his case adjudicated in a bar court, knowing that if he loses, which is almost a certainty in the way the bar discipline and bar court procedures are implemented, he would never, or she would never challenge a charge and would simply plead to the charge and to avoid the difficulties of going through the process and the potential humongous costs on the end. And those costs, by the way, I understand, are non-dischargeable in bankruptcy. So they will be paid. This is a huge, uh, this is a huge disadvantage for any disciplined attorney, which would cause, I think, almost any reasonable attorney to want to avoid the system and plead.
After signing such a stipulation, the lawyer pays a second price.
What the bar did in my case, I think I was one of the first. They published the discipline record on my bar member website. Every member of the bar, as you know, has a membership records website, and they posted their version of a summary of the discipline, which anybody that would have read that summary would certainly not hire me, because I was portrayed as a real problem attorney. The truth was, I represent my clients zealously within the law, and I work very hard for them, even at my own expense. So it gave the public that would view the summary a false understanding, if you would, or a false portrayal of who I was. And emotionally, there's nothing quite more devastating to a person who's chosen a profession like the law to find himself under a vigorous attack with a very real prospect of losing his license. And physically, I went through very traumatic times. It broke out in rosacea all over my face. I looked like a leper for quite a while. And it took me a long time to get rid of that skin condition, which was all stress-related, while I'm trying to continue to make a living after the suspension was lifted. And I'm faced with this real barrier to getting new clients. So I was very distraught for a long time.
Richard believes that an anti-lawyer attitude infects the state bar discipline system.
Most attorneys are honest and hardworking people, and the bar has has harbored a philosophy that has made attorneys look less than honest and trustworthy. And this is hurting the profession tremendously, because it's engendering a disrespect not only for the attorneys themselves, but for the law, the whole system of justice through law. And if this continues, there will be more atrocities being committed under the guise of bar discipline, and for that matter, physical harm on attorneys who are going to be perceived as persons who are not honorable and deserving of wrath, either from the state bar or someplace else.
According to Richard, it is not just the legal profession that is being harmed, but also the public.
If attorneys are afraid to zealously represent their clients within the scope of appropriate legal remedies, if they're afraid to do that, then there's a huge gap in the justice system, because clients are not being represented in the way the law allows them to be, simply for fear that of their own attorneys, that if they cross the line in some way, they themselves will be exposed and to the devastation of bar discipline and ultimate financial injury. Attorneys have a very important role in society. They can give representation to people who would not have it otherwise, and who would definitely not be able to get through the system if they didn't have legal counsel. And if you are going to impose on attorneys these due process violations, the end result is going to be fewer and fewer attorneys willing to stand up for their clients for one reason or another, and thereby depreciating the value of counsel in the society that depends on attorneys as being important participants in the justice system.
How fair is the legal process in State Bar Court? Meet Michael Crockett. He is a young Southern California attorney who was charged with a single discipline offense that the prosecutors had offered to settle with no suspension and no cost assessment.
I'm not afraid to speak out on this because I think it goes beyond myself and it goes beyond my case. I could have taken their little plea deal that they offered me, okay? And I didn't take it for a number of reasons, but one of the reasons I didn't take it is because I'm disgusted. I'm not going to be bullied, I'm not going to be intimidated, and I'm disgusted by what I see. The State Bar is only supposed to deal with ethical violations, specifically violations of the rules of professional conduct. And when they first contact you, they basically keep you in the dark. It's a lot of smoke and mirrors. So they'll contact you and they'll more or less give you a thumbnail of what this complaining person allegedly said, but you don't really know where they're going with it. And sometimes you may read what they sent to you and think, gee, I don't see any ethical violation in here, which puts you in a very uncomfortable situation because you may say things back to them that may cause them to want to attack you about something that you didn't even see. This was the first time for me that I had ever had someone, a client, complain like this. So I didn't understand what all my rights were in dealing with the State Bar.
The bar prosecutors filed a notice of disciplinary charges on September 16, 2010. The next step was to assign a judge to hear the case.
The first judge they sent me to was a guy by the name of Judge Platel. Well, I get a notice in the mail, and then buried behind that was a, quote, clerk's notice. The clerks, and they have an obligation under the statute to reveal certain conflicts, okay? Obviously, this one's a huge one, okay, that I'm about to lay on you here. The clerk's notice, and I'm laughing as I say it because it's like, some of the stuff that's done is so shocking that it's like, your mouth hits the ground like, this has to be a joke. The notice says, well, Judge Platel's wife works as an investigator in the Office of the Chief Trial Counsel with the State Bar of California. The Office of the Chief Trial Counsel is the arm of the State Bar of California that prosecutes you, basically attacks you. So the judge's wife works for the office, works for the party that's going to be attacking you. Gee, I hope that's not a problem for you. You know, it kind of is a problem for me. So naturally, I immediately moved to disqualify him.
Mike's case was reassigned to Judge Richard Hahn. Mike did not think that he could get a fair trial with Judge Hahn either.
So I immediately moved to disqualify. And I told him on the record at that hearing, I said, I am aware of your involvement in the Richard Fine case and what happened to him. And I said, all I'm looking for is a fair hearing, a fair trial. He refused to let go of the case, which is exactly what he did in the Richard Fine case.
Mike's case went into the discovery phase, and this is when lawyers gather and exchange evidence before trial. This often includes demanding evidence from the other side and taking depositions.
I propounded discovery. The State Bar's initial response, State Bar Counsel, Office of the Chief Trial Counsel, gal's name is Jessica Leno. She flat out, and she wrote it in an email, she refused to answer discovery period, which is outrageous. She claimed that it was late or something, so she didn't have to answer. So I had to move to compel answers. Finally compelled answers, and the answers that I got, you can't even really call them answers. They were inadequate to the point of being unethical, okay? And Judge Hahn himself repeatedly stated on the record at a February 14th hearing, again and again, that the responses were improper. And don't you know that, Ms. Leno?
Mr. Crockett is correct. It is inappropriate in discovery to refer to another answer to discovery in order to make your answer.
I don't know how far we want to get into arguing this, but
No, I'm not going to get very far into arguing it because my next step is to order the parties to a meet and confer conference in person at the offices of the State Bar Court, 5th floor, in one of the conference rooms. And I'm going to order that conference take place within the next... When does your trial start? When do we have our trial?
The trial's scheduled to start on March 2nd at 9:30 a.m.
Okay, within the next 7 days, that is between now and I'm going to say the 22nd of March, that the parties are ordered to find a convenient date for both parties to meet and confer in the conference rooms, one of the conference rooms at the State Bar Court, 5th floor, in the lobby area, and sort this out. If you can't work it out, then the next step is I'm going to order Ms. Lino to provide me with a report on the 23rd as to whether or not the problems were resolved and the extent to which the problems were not resolved. And then I'm going to send you to a settlement conference where you'll meet with Judge Scott. And at that settlement conference, on the purposes only of discovery, he'll act as a special master, and he will conduct a meeting to see if he can sort out what you can't work out.
I wasn't 100% comfortable with this because trial's coming up very shortly. It also puts me in a situation where anything that she does eventually answer, and or that is compelled, I'm going to need time to analyze those facts. If there's any witnesses revealed, I need time to subpoena them. You have to give them at least 10 days, 20 if you're requesting documents. Okay. I'm going to need to look up case law. It's not going to give me enough time to properly defend myself. Okay. But nonetheless, I thought, okay, he at least says he's in agreement here. They're improper. If she doesn't fall in line, he'll appoint the special master. Hopefully we'll get this taken care of.
Mike met with the prosecutor on February 22nd, the same day that a pre-trial conference was scheduled with Judge Hahn.
Every time you think the state bar can't get a little dirtier, that they can't get a little bit more shallow and drain a little more water out of the pool, they do. I show up that day and there's a guy by the name of Kevin Taylor standing outside because Judge Hahn wasn't ready to hear us on time. He says, "Hi, I'm Kevin Taylor," and he has a duty to say he's also with the Office of the Chief Trial Counsel who's attacking me. But that he's going to sit in on the meet and confer to facilitate or whatever.
In a twist of irony, and unknown to Mike at the time, Kevin Taylor was the state bar prosecutor who had argued for Richard Fine's disbarment.
It didn't go well. And they had prepared nothing. They had no answers prepared, no responses prepared. They weren't even so much as prepared to offer me a promise that there was anything that they were willing to let go of and agree to answer. Nothing. After the meet and confer, she submitted her little report. I submitted my little report. Now keep in mind, this is February 24th, a Thursday. Trial's supposed to start on Wednesday, March 2nd. He got his little report of the meet and confer on Wednesday, February 23rd. Bang. He immediately needs to be ruling and or appoint his special master, Judge Scott, to go over this and rule. I need rulings on this. I need to be able to prepare a defense. Nothing from him. Nothing. What I was also forced to do, I filed a document that I entitled Demand for Rulings on my motions to compel discovery. Saying in detail, I need rulings here. This is ridiculous. Trial's coming up. He didn't rule on it until less than 24 hours before trial was to start. He ruled on it on Tuesday, March 1st. I get a copy of it by email in the afternoon. Trial's supposed to start the next morning, Wednesday, March 2nd. Naturally, I was floored, okay, since he had already gone on the record repeatedly stating the responses were improper. He now rules against me. I show up for trial the next day, and you're always holding out hope. Well, sure enough, he shot that motion. Every motion, shot it down. So now you're sitting there at trial. You've basically been sandbagged. not just by Jessica Leno on behalf of the Office of the Chief Trial Counsel for the State Bar of California, been sandbagged by the judge at this point too, who promised you that a special master was going to be appointed, and anything that she refused to still answer in the meet and confer, he would go over and rule on. You've now been sandbagged by Judge Hahn himself on behalf of the Office of the Chief Trial Counsel. He wrote in his ruling, for instance, and obviously this is irrelevant, and it has nothing to do with the responses being improper. He was just like grasping at straws to write something in his denial. He says, well, Mr. Crockett, or respondent, that would be me, submitted his report of the discovery meet and confer late. And I wrote, well, in my motion to disqualify, for instance, that's a lie. Okay, and it's impossible. And the audio recording of the February 14th hearing bears witness to this lie. I didn't have to submit any report. Only the Office of the Chief Trial Counsel, Jessica Leno, did. And you stated on the record.
I'm going to order Ms. Leno to provide me with a report.
And the only purpose of that document was just to let you know whether they answered this nonsense or not, and if not, here comes the special master. He also stated in there that I had complained about having to sift through 200-page files, but then he himself instead filed motions totaling over 345 pages. Well, there again, how is that relevant to their responses being improper? And as far as my motion being 345 pages, well, it was 8 motions, because she refused to answer every form of discovery 2 sets. Request for interrogatories, set 1. Demand for production of documents, set 1. Request for admissions, set 1. Interrogatories, set 2. Demand for documents, set 2. Request for admissions, set 2. So 6, excuse me. So you now have to file 6 motions. But when you file a motion to compel discovery, you've got to file the actual piece of discovery that you propounded, their actual full response. Okay. You have to file a separate statement, and I had 6 separate motions. Naturally, that adds up to a lot of time, a lot of work. You think I enjoyed it? I shouldn't have to do it.
Mike felt that Judge Hahn's rulings made his trial a sham, and he did not hesitate to say so at the start of trial. Judge Hahn filed his decision on July 1, 2011. Instead of understanding why Mike was upset, Judge Hahn treated Mike's attitude toward the state bar as an aggravating factor, and so he punished Mike more severely by recommending a 4-month actual suspension. Judge Hahn also declared that Mike suffered from lack of insight because Mike had raised defenses against the disciplinary charges. Raising defenses in court is something that lawyers are taught to do, but in state bar court, it often results in harsher discipline. As part of his discipline, Mike would also be placed on a 1-year state suspension as well as 3 years probation. Mike will be required to submit quarterly probation reports. He will also need to complete an ethics school and pass the professional responsibility exam. Failure to do any of those things will result in new disciplinary charges against him and a second strike under the 3 strikes rule.
I suppose I could have settled it out, but I chose not to for a number of reasons. I don't like it when someone tries to bully you, intimidate you. I know what's right and I know what's wrong, and I just felt like I think I try to be fair with people, and when someone's that unfair with me, no. You know when you're a kid in school, right, and your mom says, here, bully's bothering you, just ignore the bully and the bully will go away. Just like any little aphorism, sometimes they can be true, but they don't have universal application, you know. And I've always said the opposite. Oftentimes in life, if a bully goes unchecked, no, they do not go away. And that's exactly what the state bar does. Once they get you to agree to something the first time, okay? And a lot of attorneys, they're probably busy, embarrassed, they just want it to go away, they're worried about their reputation. Well, mistake, pal, because it ain't going away. They're just going to dig it up at some point later. And it's almost a guarantee that they're going to dig it up, because now that they got you to agree to something the first time, it makes their job that much easier the second time, because they'll pull it out and say, you want to go to trial this time around, we're going to pull out this thing from before. Oftentimes attorneys have no choice but to go to trial the second or third time around, because they do have all this prior nonsense that they played nice on and agreed to. and the penalties get so severe that they're like, gee, I have to go to trial on this now. I'm willing to speak up and I'm willing to stand out. A lot of attorneys aren't. I mean, they wouldn't do what I'm doing right now. They wouldn't go on camera saying any of this. I will because, and I understand I'm taking a risk, that there could be quote unquote repercussions, okay? Judge Hahn, amongst others, isn't going to like what I have to say. I don't care, and I'm willing to speak up, and I think that if everybody spoke up, we wouldn't have a lot of the problems that we have.
My ordeal with the State Bar lasted about 7 years. It began with a letter in early 2005. It finally ended in 2012 with the Supreme Court's refusal to hear the case. During that time, my case was transferred back and forth between San Francisco and LA, and every State Bar Court judge was involved in my case at one point or another. So I think I got a pretty good idea of how things work, at least from the point of view of somebody who's been accused of misconduct and who has to go through this system. I probably had about a half a dozen State Bar prosecutors assigned to my case. What they do is at every stage of the case, they assign somebody different. There were, I would say, at least 3 chief trial counsels that kind of came and went during my time. And there were at least 6 State Bar presidents because they pick a different president every year. What struck me in all of this, despite all this seeming change, was the consistency with which the State Bar operated in terms of its prosecution. And it wasn't consistency in a good sense. It was a consistency in a sense that was rather shocking to somebody who's never been involved with it, and certainly was to me. My case arose out of handling of trust funds in divorce cases between the years 2001 and 2005. I was handling up to 11 clients, 10 or 11 clients at a time during that period. 2 of those cases involved complaints to the State Bar. One was from a client. I'll call him Smith. That's not his real name, but I do want to still go ahead and honor my client's privacy. And so he didn't really complain about the trust funds per se. He really complained he thought I charged too much for his divorce case, which was one of the ugliest, nastiest divorce cases that I had ever handled in 20 years of law practice. But I guess there's a common wisdom that that's going to be the client who's eventually going to complain to the State Bar. And then the other one was not my client. I had represented a husband in a whole different divorce case, but it was actually his wife who had complained. She said that I should have paid her $14,000 instead of $11,000, even though the court order said I was only supposed to pay her $11,000, which is what I paid her. But in investigating the case, the State Bar saw that I had placed the Smith money into an account at County Bank, and it was called a non-IOLTA account. Now let me explain what these accounts are. The State Bar basically has 2 types of accounts that lawyers will use. One is the State Bar account. It's called IOLTA, I-O-L-T-A, which means Interest on Lawyer Trust Accounts. And what that is, it's a program whereby an account is set up under the name of the State Bar with the attorney as the trustee. And then that account then is used for quick transactions, like money that's going to kind of come in and go out fairly quickly, or very small amounts. And in both of those scenarios, it doesn't make sense for a lawyer to have to go out and set up a whole separate account that's going to either be too small to make it worthwhile, or that's going to be dealt with quickly, that might be closed in a month or 2. So pretty much every state has IOLTA programs, and then the banks pay interest on that money, and that money goes to the State Bar for use in their low-income legal assistance program. So it's not a bad program. But then what happens, though, with longer-term money or larger sums that it's going to stay in the account for a long time, for example, divorce lawyers who have very messy divorce cases that they kind of know is going to go on, it's going to drag on for 6 months or a year or 2 years or whatever. If they get money, let's say, from the sale of the house, they will typically open up a separate non-IOLTA account with a bank, and then that interest is then accrued to the benefit of the client. So the clients eventually get the interest instead of the state bar. In divorce law, at least at that time, during those years when the economy was going great, and especially in Modesto, where I was doing most of my practice, the real estate market was booming. Pretty much everybody had equity in their homes. So when they sold out during a divorce, or if they had a successful business that they sold out, but the divorce was going to drag on for a while, you would typically set up that money in an IOLTA, a non-IOLTA, non-state bar account for the benefit of that client. And the client's name would be on the account, and then the transactions on behalf of that client would, of course, be reflected in the activity on that account. It was very common for busy divorce lawyers such as me to have the state bar IOLTA account for the short term or quick money, and then to have one or more non-IOLTA accounts, which were set up for the benefit of these different clients. So that was my state bar IOLTA account, and then 3 non-IOLTA accounts set up in the names of the clients. The main issue that I was worried about was the fact that when you set up a non-IOLTA account, the attorney's social security number or tax ID number has to go on the account. It shows up as the attorney's account. The state bar IOLTA accounts, the state bar assigns the state bar's tax ID number to that account. And here's the problem, is that if a lawyer has a judgment creditor or a tax creditor, and they're setting up these non-IOLTA accounts that has their tax ID number or social security number on it, that account can be attached by one of the lawyer's creditors. The client can actually lose money because the lawyer has a judgment creditor or tax creditor. And this was a real concern to me, because I was having a dispute with the EDD, the California EDD, which is the Employment Development, whatever that is, over some payroll taxes, over who was an independent contractor and who was an employee. It's a very common dispute, eventually got settled. But at the time, they were demanding thousands of dollars in employment taxes. And so what happened with the Smith account, I was really worried that they would come in and levy the Smith account, and that they could levy any non-IOLTA account on which I had my Social Security number. So I did not want to leave that money at County Bank. Meanwhile, 2 of the accounts that I had, the non-IOLTA accounts, they were out of state, they were in jurisdictions and set up in a way that they couldn't be attached. My Social Security number was not attached to them. And so they were very safe. So I made the decision, I'm going to go ahead and primarily rely on those 2 other outside accounts. And it worked out fine. I mean, the State Bar acknowledged that all the trust payments got made. The State Bar judges recognized that there was no harm to any client. My concern about being levied was not some far-fetched concern. It actually happened. The Smith account was actually levied. It was levied, I think, in 2003, late in 2003, by EDD. By then, I had all of the Smith money in these other accounts, so EDD only got, I think it was something like $12 out of that account. And I saved my clients thousands of dollars because the EDD was after several thousands of dollars, but that money was now in an account where creditors could not reach it. And I showed this to the prosecutor, I showed it to the judge, at least I pointed it out to the judge. It was part of the records that they admitted into evidence. And it's like it fell on deaf ears. The judge then made a finding that somehow that by not keeping the money at County Bank, that I had endangered their money. I swear to God, he wrote words to that effect. And then the review department, after I appealed it there, they wrote words to similar effect. When in fact the evidence was exactly the opposite. They made no harm findings. Judge Miles and the review department made findings that I had not harmed any clients. In other words, no clients came to any harm. Judge Miles made a finding that I had paid all of the payments on time in the Smith case. And I showed them evidence that there was a levy that was directed against the Smith account that did happen. But then it was not on paper, but I remember one of the prosecutors, or perhaps it was a judge somewhere along the way, made the comment, well, why didn't you replenish the Smith account? Because after that levy, just a few months after that levy, I just closed the Smith account. I didn't want to use it anymore. I wasn't going to use an account that had already been attacked with a levy and keep client money in there. I was just going to use these outside accounts, and it worked fine. The Smiths got all of their payments when they came due. So I said to them, okay, well, look, let me prove that I had the money in trust accounts, that these other accounts were, in fact, also trust accounts. You're recognizing the existence of these other funds. Let me prove to you that they were, in fact, trust funds. But in order to do that, because they were set up with the names of other clients who had not complained about me, I need a seal placed on those records. What a lot of people don't know is that the State Bar is not entitled to financial information from clients who have not complained about the lawyer. And in fact, the lawyer is not allowed by law to even give that information to the State Bar. Unless the money went through the State Bar trust account. Then the State Bar is allowed to get all the records from the State Bar trust account. And if client money went through that account, then they will find out and they will know about that. But if the money has gone through a non-IOLTA account set up individually for the client, then the lawyer is not allowed to do that unless there's a seal. There is a procedure for a seal in the State Bar rules. It's called Rule 5.12. It used to be called Rule 23, but now it's called 5.12. And it's this whole procedure for sealing records for lawyers who are exactly in my situation, that in order to defend themselves against disciplinary charges, they need to disclose confidential information from other cases from clients who have not complained about the lawyer and who are otherwise entitled to constitutional protection. The right to financial privacy is a constitutionally protected right. But the prosecutor then said, no, we're not going to agree to that. The State Bar proceedings are open to the public. There's a public policy that favors openness. We are not going to agree to that. And I explained, well, how can I show you the records that you want to see? How can I defend myself against this misappropriation charge unless I can show you these other trust account records? And there was really no explanation. It was just this catch-22 that they put me into. And in fact, the two clients who had set up the other two accounts, or for whom I had set up the other two accounts, plus a couple of other clients actually went to a separate lawyer during the investigation phase in 2005 and actually filed a motion for protective orders when they were trying to get some of the IOLTA records. And the State Bar judge declined to give them any protective orders to protect their financial privacy. But as we approached trial, I then filed a motion for a seal. Again, we were finally assigned to a trial judge when we couldn't reach a resolution. It was Judge Miles in Los Angeles, was the one who eventually became my final trial judge. I filed a motion to seal the records. The first motion was denied. It was perhaps a little broad. I had asked that the entire case be sealed because it just seemed easiest that way. It was just about trust funds. You can't talk more than 10 minutes about my case without then having to talk about these other trust funds. Then after that, I filed another motion to seal, and I asked that it just be, just the records regarding the non-complaining clients. Anyway, the judge didn't rule on it because of some other procedural things that happened in the meantime. But then, as we got closer to trial, I revived that sealing motion in my pretrial statement. And I said, okay, one of the things that we need to deal with as a matter for the trial is we need to get a ruling on my motion to seal these client trust records and to seal all information related to clients who have not complained about me so that I can present my defense. And also it went to my mitigation case, the fact that I was acting in good faith, I had the money and all of that. So we got finally to the first day of trial. And the judge listened to my argument.
It's my thinking right now, although I could be convinced to the contrary if you have some authority, that there is a duty here on the part of the State Bar where you gather information that you know to be private, that you have a fiduciary duty not to disclose that, not to invade that, not to interfere with that right of privacy by voluntarily making public the information unless there's a compelling reason. I don't see the reason here, given that there's no claim of misconduct related to those other individuals. So it does strike me that to the extent that people are in a relationship with an attorney and he's handling their monies and he's making payments on their behalf, that they may have a right of privacy and there may be an attorney-client privilege that applies there. If that's not been waived and it's not relevant here, it seems to me that the State Bar may have a duty to not violate those rights of privacy, but rather to protect them. If I'm right about that concern, let's figure it out before we close the record.
And I will submit that brief, but I will say that it is the standard practice of the State Bar to submit all of the records. Okay. They aren't violative of the... I don't care
what the practice is. I want to know that what we're doing is right. I want you to brief it, and if you're right about it, then we have a brief, and it'll be clear to me that what we're doing is correct. If your standard practice is inappropriate and you're violating people's rights, let's don't include one more person to the list of people that have a legitimate complaint about what's happening. I think we have to be sensitive to the rights of privacy of people that are not complaining witnesses and who might be very upset to find out that their financial transactions are being made a matter of public record by the State Bar without their knowledge, without their approval, over the objection of their attorney.
I was very pleased when he said that, hey, let's not compound this error. Even if the trial counsel's office has been doing this as a matter of course, let's not compound the error. We're going to stop it here with Mr. Darlene's case. So I kind of said, all right, thumbs up to Judge Miles. I'm actually liking this judge right now. He's protecting my clients the way I wanted to see them protected. Anyway, I was a little naive as things kind of went on because the next day, Maria Oropeza came in and delivered her report.
Your Honor, you had asked that I look into the privacy rights of the non-complaining witness, non-complaining clients, and I found two State Bar cases relevant to the issue. Okay. Doyle versus State Bar addressed the issue, and so did in the matter of Respondent W. And pursuant to those two decisions, the solution that the State Bar Court has used in the past is a Rule 23 motion sealing those records pursuant to Rule 23 by balancing the need for the records and the rights of the non-complaining clients through privacy. And they indicated, Doyle has indicated, and so does Respondent W, that it is the attorney's duty of informing the client or clients whose trust account information may become public of that fact when it comes into play. So I think the best thing to do would be to go ahead and seal those client trust account records.
Well, when Maria Oropeza said that she actually agreed to the concept of a seal, I think my jaw must have just dropped to the floor because this was the first time in, oh gosh, how long I've been battling the State Bar by that time, at least 5 years by the time we got to trial. Yeah, it was about 5.5 years. And it was the first time that anybody in the prosecutor's office had finally agreed with me to the concept of a seal on anything. So I was suddenly getting very optimistic at that moment. Okay, here was Judge Miles agreeing with me that the client confidentiality was very important. here's Maria Oropeza saying, kind of in contradiction to what she said before, that they would just release the records. Now she was saying that they had this practice in situations like mine of sealing these types of records. So I started seeing this sea change on perhaps the most important issue in my defense. The most important issue in my defense was getting that seal so I could then say, okay, here are the records you need to see. Here's the information I need to give you. Here are the details of the money that I had, who had the money, how I was handling the money on behalf of the clients. I can now give you the details with specifics, with records. I had a lot of records with me at the trial that I brought with me that I was ready to go ahead and show the judge. But then, before I really had a chance to open my mouth, Judge Miles decided he didn't want to seal records because it was too much of a hassle.
It seems to me that other than take all of the time and logistical problems of sealing the document, which creates all kinds of issues if there's an appeal.
What he did was he did protect my clients. What he did was he said that any evidence regarding those clients that had their names on it, for example, canceled checks from the IOLTA account, they would not be introduced into evidence. But I needed it in the form of a seal, not in the form of, okay, all that evidence cannot be discussed or introduced. I need it in the form of a seal where it can be discussed and introduced so that I can defend myself, but at the same time, that information will not be made public. That's what my whole motion was about for the seal. At that point, I was just sunk. Of course, it's a hassle to seal records, but that's contemplated by Rule 5.12, or as Maria Oropeza called it, Rule 23. Of course, it's a hassle. But that's sometimes you have to go through hassles to give people justice. Giving people justice and making sure that you have a system that gives them justice involves hassle. It involves money. It involves paying judges. It involves paying clerks. It involves doing things that take a little bit of time. And it was disappointing to me that Judge Miles did that, to say it mildly, because I had no defense anymore. So then Judge Miles came out with his written decision after our little 2-day trial. And he said that the evidence that I presented about the other 2 trust accounts was neither credible nor sufficient. Well, of course it wasn't. I couldn't say anything. I couldn't show him all the documents that I had brought with me. I couldn't kind of chart the flow of funds for him and give specifics about how much those clients who'd set up the other accounts owed me in fees, which played a role in all of this. All of that stuff, real specific stuff, played a role in it. So of course it wasn't sufficient. I knew it wasn't. But then he adopted the finding that I had made many of the payments from other funds outside of County Bank, or at least outside of those 2 accounts at County Bank. So it was a contradiction, okay? He's saying it wasn't credible or sufficient that when I said, okay, I had other trust funds, but then he says, yeah, that I had other funds. But then he wouldn't say what those other funds were. I mean, it just kind of drives you crazy. And this is not what a lawyer who's practiced a long time, this is not that I was accustomed to experiencing in the superior courts. I mean, there the judges kind of want to get down to the bottom of things. They want to know the facts, and they're not going to leave important facts like that open. I then raised this issue in my appeal to the review department. And the review department, they asked me during oral argument, well, what about redacting? Redacting means that you black things out, or you take a scissor and you cut them out of the documents so that you can still present documents, but you cut out the information, or you black it out so that you don't violate the other client's privacy who aren't involved in the case. I pointed out during the oral argument that A, the clients who had set up the other accounts wouldn't agree to a redaction. They would only agree to a seal, that they were just completely closed from the public. And I pointed out that Rule 5-12 deals with sealing. That's what 5-12 is. It's just dealing with situations exactly like mine, where in order to defend yourself, the lawyer needs to go in and present some other evidence like that. And there's only one sentence at the end of Rule 5.12 which talks about redaction, which just simply says that the files or the records may be redacted. It's just sort of an option if it's appropriate. But it didn't say, Rule 5.12 doesn't say that redaction is the preferred way to do it. It doesn't say that that's what you're supposed to do first. But the review department judges, they just sort of made up this rule saying, well, you're supposed to redact. You're supposed to do that as your first option, even though there is even though there's nothing in Rule 5.12 that says that. They had this habit, the judges of the State Bar Court, and when I say judge of the State Bar Court, it's really Judge Miles and the 3 review department judges, that they made up kind of these special rules for me, all of them which were not in my favor. They basically said, by the effect of their rulings, is that once you put State Bar, or once you put trust money into a certain trust account at a certain bank, it has to stay there. And you are no longer allowed to keep that money or keep those sums in another account for those clients. It has to stay in that account. There is no such rule, but they made it up for me. The biggest problem that I had with the State Bar, and the reason why the fight really went on as long as it did, was this factual stipulation that they wanted me to sign was so incomplete that it became distorted. It was really a very distorted picture they presented through omission. Anybody reading it would think I had just pocketed a lot of client money and run off with it. They didn't make it clear that the trust payments were made timely and in full, even though it's implied between the lines. For example, I'm not accused of not having made any trust payments. They never said that when trust payment A came due, Darlene failed to make it. No, nothing like that at all. And they put in wording that said that instead of paying from the county bank accounts, he made many of the trust payments from other funds. But most people miss that. It's very easy to miss that. This is when I got introduced to the State Bar's game of slippery slope. And what that is, it's a very childish game. What it is if you don't agree with them, if you don't they have a take it or leave it there in the beginning. Either take this, and if you don't like it, then we're going to just make it worse for you. The longer you keep fighting us, the worse we're going to make it for you, and the worse our demands are going to be. And it wasn't because they discover something new about your case that now puts it in a worse light. No, it's just that if you don't agree with them and just do what they say, they're just going to keep punishing you by making it worse and worse and worse. So that's what Maria Oropeza was doing. So the only thing Maria Oropeza would do is she would put in a little sentence at the end saying that I paid restitution. You know, restitution also sounds like you pocketed money and ran off with it, and then later on you made it up to the client for the damage you made. That's kind of what restitution implies to most people. And I said, well, you know, this one sentence about restitution at the very end doesn't explain, you know, what actually went on with the money. Could you please make it clear? It's just really easy to do. It just takes a few sentences to add to this thing. She wouldn't do it. She says, no, it's just written up just fine. As we approached trial with Judge Miles, who became my final trial judge, we were about 2 weeks away from trial. And we were scheduled for a settlement conference with Judge Platel in Los Angeles. By then I had been told that if I pursued trial, I'm going to owe all of these cost assessments to the State Bar. I was told by the judges and by Maria Oropeza that those charges could go potentially as high as about $30,000. That is, if I insisted on a trial, then either side could go to the review department, which would then add on more money, and then if it went to the Supreme Court and they agreed to take it, it could cost more money, and then if it went to retrial, more money. So they were basically adding up the fact that this thing could cost me, and they were saying about $30,000 in cost assessments. And these are non-dischargeable in bankruptcy. What they didn't say to me, but what I had learned by that time, is that the California Supreme Court can affix additional penalties on top of those cost assessments. I didn't want to mention it to the state bar prosecutors or even to the judges when I discussed this factor in my decision, simply because I didn't want to remind them of it, so they didn't ask the California Supreme Court to impose those on me. But it was always in the back of my mind this whole time. The Supreme Court can go ahead and assess up to $5,000 per charge. And the state bar had 12 charges against me. You know, a lot of them were duplicative. It was sort of the same conduct, but it was just defined in different ways. So then I had in the back of my mind this knowledge that I could be assessed as much as $50,000 more by the California Supreme Court. $50,000 was the maximum. I was at risk of owing the state bar $80,000, as much as $80,000, if I did not sign this false and distorted stipulation. It was non-dischargeable in bankruptcy. I don't know what the legal rate of interest is today. I remember back then, right around then, it was like 10% per year. So not only was I risking a non-dischargeable debt of $80,000, but on top of that, my understanding is they could then add 10% per year and compound it. Pretty soon, if you don't pay, so if you don't pay that $80,000 right away, pretty soon you're up owing them $100,000, and that compounds. You're owing them maybe by a couple $100,000 eventually, you know, in just a matter of less than 10 years if you don't pay it off. It was kind of almost a life and death decision because I did not have health insurance at that time. I have a family history of colon cancer. My father died of colon cancer. My mother had heart issues and diabetes. So diabetes also ran in the family. That money could have meant the difference between whether I get medical care or not if some of these things came up. That money could have meant the difference whether I could buy medicines if I started developing any of these conditions. And I was already starting to experience hypertension, that is high blood pressure. It started happening during this process with the state bar. I was gaining weight during that time. Part of the problem was that I had to keep reliving the deaths of my father to colon cancer and the deaths of my significant other to illness, which all happened during this period of time that we were talking about the trust account. So I had to keep reliving and rethinking those years, and I was developing health issues. It was like having a gun to your head. It was either like sign or face as much as an $80,000 non-dischargeable debt that could leave you, that could basically shorten your life later on if you don't have the money later to pay for medicines and things. So I signed it. It had all the distorted things in it. And I walked out thinking that we were done. I don't know how much time passed. It wasn't much time. But the stipulations have to be approved by the assigned trial judge. So it had to be approved by Judge Miles. He refused to approve it. Basically, in so many words, he said, well, the punishment isn't severe enough, given what's written here, that we now need to go to trial. I called Maria Oropeza. I said, okay, look, Maria, look, nobody, because of how you've written it up, we can't even get the judge to agree to this. Will you please agree to a more accurate write-up, a more balanced write-up so that we can get this approved? No, she said. No, this is fine. This has to be the way it's going to be. And why don't you just agree to a disbarment? And what really got to me is she giggled when she suggested that to me. She actually giggled. That's when I realized just how much she relished this power she had over me. She enjoyed this catch-22 dilemma she had put into me because I could tell that it fed her. It fed her self-esteem. It fed her sense of empowerment to be able to put someone like me into a position like that. I said, I had to think about it. I said, I'm just going to resign with charges pending. I can't go through with this trial and face that kind of a debt. Maria agreed to that. At the time that I signed the resignation with charges pending, it was, I think, either in January or early February of 2010. A new rule had just taken effect in January 2010. That new rule says that if you resign with charges pending, you have to sign a stipulation as to the facts with the prosecutor. Prior to that, if you resigned with charges pending, you didn't have to sign any statement. You didn't have to make any kind of a confession. You could just resign and you are out. But they felt that lawyers were getting away with something by being allowed to do that. So I guess I'm not sure if it was a legislative enactment or if it was just a state bar rule. I think it was legislative. They decided they needed to get tough on lawyers again. And of course, it's an illusory toughness because when you resign with charges pending, you are giving up everything. It's the same for all practical purpose as a disbarment, because if you resign with charges pending, you can't apply for readmission for, I think it's 5 years or something like that. I mean, it's basically the same thing with a disbarment. You have to wait 5 years to apply for readmission. So there's no winning when you, even before that rule, there was no winning with having to resign with charges pending. But now they decide, okay, we got to make it tougher now. So basically, now the rule becomes, if you want to get out of this organization, if you're just sick and fed up with us, if you just cannot stand us anymore, we're not going to let you go. You either sign a false confession to be allowed to leave, and if you won't sign this false confession, now we're going to make it go to one of our little trials, and we're going to charge you for that trial, whether you show up or not. Sure, maybe you won't have to pay as much if you don't show up, but we're going to still charge you a bunch of money. It was like you're part of a mafia family. It's sort of like they're saying to you, okay, we've formally accused you of doing something bad, and if you think that we are mistreating you and you're sort of sick of us now because of how we're treating you over this, we're just not going to let you go. You're going to either pay us a lot of money or you're going to sign a false confession to be allowed to leave. And that's your choice. Okay, now the resignation doesn't go to Judge Miles. It goes now to Judge Remke. Judge Remke is, or at least was at that time, the presiding judge of the entire State Bar Court. She's head of the review department and the presiding judge over all the judges. She now is the one who's supposed to approve the resignation with charges pending before it goes on to the Supreme Court, the California Supreme Court, for approval. She sent back an order. It was dated like May of 2010. She didn't approve or disapprove it. What she did in the order was she said, well, wait a minute. What happened to the money? Did the clients get all their money? By reading the stipulation that Maria Oropeza insisted on and that I finally caved in on and signed, even the presiding judge of the State Bar Court couldn't understand if the clients had gotten their money. Now, by this time, there was a new deputy trial counsel assigned to the case. She later got fired, but at the time she was still working for them. She was now the one assigned to this process of doing the resignation. I thought, okay, there's hope. I'll call her. Now, even the presiding judge doesn't understand. This is exactly what I have been trying to get Maria Oropeza and the prosecutors to put into the stipulation all along. That's exactly the information. What the State Bar presiding judge, what Joanne Remke said that she wanted to know was the timing of the payments, how they got paid, exactly the information that I had wanted Maria Oropeza to put into the stipulation. So I felt a little bit vindicated by Judge Joanne Remke. I thought, okay, finally somebody seems to be getting it. So I called this new deputy, and hopeful that I could get her to make the changes so that we could resubmit it. And she says, no, I'm not authorized to make any changes to the stipulation itself. I can, if you want to negotiate this, if you want to make changes, you have to call Maria Oropeza. I knew that was hopeless. The only thing they would do is they would send in a supplemental pleading that would explain it. And I sent in a supplemental pleading explaining it. The trouble is that supplemental pleading does not get posted on the internet. The reason why I was so concerned, and I've always been so concerned about the stipulation, is the State Bar posts it on the internet for the whole world to see. It's posted right there as part of their website. But the supplemental pleading that explains all of this, that clarifies all of this, does not get posted on the internet. I then just kind of got fed up. I didn't care about the $80,000 anymore. I kind of came to this realization that what happens in this world, it's just since human beings have started walking this earth, justice has always had to be fought for. And there are always going to be people who are going to die for it. There are always going to be people who are going to pay big penalties to try to pursue justice. And if they are not willing to do it, if you are called on to make that sacrifice and you don't do it, you make a worse world for everybody, because that's what it takes. I didn't want to be the person who was called on to have to do that. I didn't want to be the person who had to risk that much money and the impact that it could have on my health and my longevity. But I realized then at that moment that fate had sort of cast the die, and I felt a little bit ashamed that I had signed it, that I had kind of given in, because that's not the kind of personality I've been. I've always tried to be fair to people. I've always tried to, try to achieve justice as a lawyer. And I realized that I had to go all the way through this, regardless of the consequences to me. So what I did was I then filed a motion to Judge Remke asking to withdraw my resignation and to set aside that stipulation, and let's just go forward with this trial. The resignation had not been approved yet by the California Supreme Court, so my request was timely. And the only reason I had signed that stipulation was not because we were getting ready for trial, it was because it was required as part of that stipulation. I never would have signed that ridiculous thing if it hadn't been required in order to be allowed to resign under this new rule that took effect just like a month before I had been put in the position of having to choose. So I sent this request to Joanne Remke. She sent back an order saying, okay, you can withdraw your resignation, but you're stuck with the stipulation. You're stuck with the stipulation for the simple fact that you signed it. Even though, and she didn't say this in the order, but it's implied that, yeah, I'm stuck with it, even though she herself saw the defects in it, even though she could see it doesn't tell the story. Even though it lacked information that she herself felt that she needed in order to make a judgment about me, in order to be able to decide what kind of person I was and what kind of lawyer I was. But she decided that the public didn't need to know that. It wasn't important to the public. I was stuck with it just because I had written my name on it. As we approached trial, I filed a motion to Judge Miles asking him to set aside the stipulation. Now, you're probably thinking to yourself, well, that was kind of a ballsy thing to do, considering that the Supreme Judge over all the judges has just said that you can't set it aside, and her orders are typically binding on the judges below her, which included Judge Miles. Why would you do such a thing and waste the court's time? And that was basically Maria Oropeza's position. But I pointed out that any order of the review department, I pointed out several things. A, the order of the review department took 60 days to become final. And the Judge Remke had ordered an expedited trial, so the trial was set to start before the 60 days ran out. So the judge was, her order, making it enforceable, was not binding and final at the time we started the trial. I also pointed out that it was signed under considerable duress, and I also pointed out that I felt that the review department was required to give me a hearing, a live hearing on that kind of a motion under one of their rules. It was Rule 300 something that I cited. So on those three bases, I said, that order from the review department's not valid. I would like you now, Judge, to set it aside and just proceed with a full trial on all the issues. When we got to the first day of trial, I brought up the fact that I had this motion to set aside the stipulation pending, and I needed a ruling on it because if it's granted, then Maria Oropeza would need to present a full trial. She'd need to have all her witnesses. She hadn't brought any witnesses. She was just relying entirely on the stipulation for her case, even knowing that I had this motion to set it aside, which would put her into some jeopardy of presenting her case if it prevailed with Judge Miles. So I was expecting a ruling that morning because that made a big difference on what we did. He did something really unusual. What he said was he's going to take this stipulation into evidence. And he said this right at the beginning, before I even had a chance to start my case. It was at the beginning of Maria Oropeza's case. The prosecutor always goes first. And he's going to take it into evidence subject to me filing a motion to strike.
I understand from your paper you filed this morning that you're disputing whether it was voluntary or not. Is that the case? All right. Okay, here's what I'm going to do is I'm going to receive the stipulation in evidence. That's Exhibit 67. Okay, I'm going to receive it in evidence subject to a motion to strike based upon any evidence that causes me to conclude that the stipulation is subject to a collateral attack that based on whether it's voluntary, coerced, or some other basis that will allow or cause this court to conclude that the stipulation was not enforceable. I'm concerned that the review department's decision is not final at this point, and if it's not final, I don't think I should rely on it, and so I'm not going to. But I do have a signed stipulation. The stipulation by its terms indicates that it's binding in this situation. So unless the stipulation as a whole can be set aside based on voluntariness or some other reason, I'm going to accept it. I'll accept it in evidence, but I'll make it subject to a motion to strike.
Okay, now the motion to strike, do I need to make that now as an oral motion at this point?
Well, I think you're going to need to. I don't think I can, based on an oral motion, conclude that the stipulation wasn't voluntarily entered into. I'm going to have to present some evidence.
Okay.
That will allow me to make that finding. And so if he has evidence, I'm going to allow him to present that evidence, and then I will rule on it for purposes of whether the document will stay in evidence or not. That gives him a full opportunity to be heard on this issue, gives him a trial on the issue, and if this stipulation shouldn't be binding, as an example, if you had a gun to his head when he signed it, it shouldn't be binding.
Now, because it had to be a written motion, and he didn't do what's called shortening time, like saying, okay, well, you need to file your written motion by tomorrow, and then I'll rule on it tomorrow. The normal rules of notice and all of that would apply. In other words, I would have to send it to opposing counsel. She'd have a certain number of days in which to respond. And then at that point, there'd be a hearing set, which would, of course, have to take place well after the trial. So I couldn't understand this. This is very puzzling to me. So you kind of go into trial, okay, it's in evidence, and the only way I can get it out of evidence is by filing this motion to strike. And, of course, you don't give testimony and evidence in regard to a motion that you haven't yet filed, so of course I'm not going to give evidence about whether it was voluntary or not and the coercive effect of the cost assessments. That's something that would have to come later after I'd actually filed the motion. Okay. At least that's how I had always experienced it in the superior courts. And Judge Miles said nothing different. He didn't shorten time saying, okay, no, even though you're going to file your motion later, I need to hear the evidence at this trial, kind of in reverse order. Nothing like that was said. So we expected to do it in the normal way. So it was in evidence. what do we do? Are we doing a trial on the underlying facts? Because if we are, then I would proceed differently. If the motion had been granted, then Maria Oropeza, let's say, well, if the motion were granted later, after the trial, then Maria Oropeza would have lost her trial quite automatically because she would have had no witnesses to prove any part of her case. So it's very confusing. You know, it reminded me of this Three Stooges bit in the courtroom.
Take off your hat. Now raise your right hand. Now place your left hand here. Take off your hat. Raise your right hand. Now put your left hand here. Please take off your hat. Raise your right hand. Now put your left hand here. Will you please take off your hat?
So by the end of the trial on the second day, I was getting ready in my mind to file this motion to strike within a few days. And as soon as we went off record, and then we just started chit-chatting, and I wish it had been caught on record, but it wasn't. So you'll have to take my word on this. I've made a statement under oath that this is what happened. Judge Moss started chit-chatting about his plans for the week. And what he said was that although this trial had been scheduled for a 5-day trial, he was supposed to be there 5 days to do our entire trial, which would have taken, if Maria Oropeza had to do her entire trial, and we put on all the evidence without that stipulation, yeah, it would have taken 5 days. But he had scheduled some conflicts. He had other things planned for later that week, and if the trial went any longer than 2 days, it would have interrupted those additional plans that he had made. As I recall, one thing he had scheduled was to give a talk on legal ethics somewhere. Anyway, so then I understood why Judge Miles did this weird procedure. He had not set aside the 5 days that had been scheduled. He had only set aside 2 days. If the trial had gone, if he had ruled in my favor, or even if we just had the trial on whether or not it was voluntary or not, if I'd given testimony and presented documents, which I had with me, you know, that would have taken half a day, maybe even a full day. And even if he had ruled against me on that at the end of that trial, we never could have done the additional 2-day trial, which it took to do the rest of it, within his 2-day time limit. So it made sense to me all of a sudden why he bumped it over, why he decided he wanted to kind of rule on this later. Plus, let's say he had ruled in my favor, then Maria Oropeza would have had to ask for a continuance of the trial anyway so that she could subpoena her witnesses and come back and have a real trial. So I kind of understood. And it stopped bothering me quite as much, that is, until I received his decision. And I cannot believe what Judge Miles did. What he said in that decision is that my motion to strike, because I did submit my motion to strike in writing afterwards to him, Maria Oropeza sent in her opposition. She apparently thought that the procedure was the same as I thought it was. Judge Miles said, all of my motions to strike the stipulation are denied, and I had a chance at the trial to present my evidence and testimony, and I didn't do it. And because I had not presented my evidence and testimony at trial in regard to the motion to strike, I therefore was not going to be granted that motion. I mean, it's like putting the cart before the horse. I felt so betrayed by Judge Miles, and I instantly then understood his reputation and why he got it. This was something I have never experienced in any courtroom, any superior court I've ever been in. That type of treacherous procedure from a judge. Now, when I was preparing my petition to the review department to overturn what Judge Miles had done, that's when I discovered that Judge Miles had never signed the form that the state bar judges are supposed to sign when they approve a stipulation. There's an actual form which makes certain findings. The judges are required to make certain findings, and to approve it. And that's very similar to how it is in the superior courts. Let's say the parties are in a case, they enter into a stipulation where they agree to the facts, they agree to the outcome, whatever it is. It always has to be sent to the judge, and the judge has to approve it. It doesn't become an order, it doesn't become anything until the judge approves it. So as a family law attorney, I learned to always tell my clients, don't do anything in reliance on a stipulation that you've signed until the judge approves it, because they often kick them back. There's often something that is wrong with them. There's some order that they want in there. There's some facts that they feel need to be stated. And so it often happens that the lawyers have to kind of redo the stipulation, have the clients re-sign it, and send it in. So there's a similar procedure in state bar court, and there's a form for it that the judges are supposed to fill out. I found out when I did my review, because I went then I looked through the court file and also through my own file to see if I'd gotten a copy. That was not signed by Judge Miles. Judge Miles never signed that form approving the stipulation. Anyway, I pointed all of this out to the review department, and it's mandatory that the judge in the state bar court has to approve these. It's not discretionary. It's not just something they can or cannot do. It's required because there's a public interest served by it. The public interest is the public protected, and is there justice here? Just the fact that you put a statement into a stipulation saying this is binding once you sign it, that provision itself is not binding until the judge approves the whole thing, which includes that provision. In other words, any provision, any factual finding, anything like that, my experience in the Superior Court was always that the judge has to approve it before anything in it becomes binding and enforceable. And I saw nothing in the state bar court rules that made it any different in state bar court. So I pointed this out to the review department. I pointed it out in my written review request. I pointed it out during oral argument. I mean, I really pointed this out. I said, well, wait a minute. There's been no formal approval even of this stipulation. Of course it needs to be set aside. And how can you enforce it? Well, the review department, they just simply took the opinion that, okay, once you sign it, that's it. It doesn't matter if the judges follow the rule that requires them to execute these approval forms. It no longer matters. So I'm telling you, if you are a state bar hearing judge watching this and watching me talk, you don't have to worry anymore about whether or not you sign that form. It's going to be enforced against the lawyer anyway. Again, it seemed to be like this special little rule that the review department judges made just for me. But I'm being a little facetious when I say that because I've seen it as a pattern of conduct. They are so much aligned with the purposes of the prosecutors that they will step over any rule, especially any rule that favors the accused lawyer. They will just step over those to get the end result they want. In my case, they wanted me heavily disciplined. They wanted me disbarred. So they stepped over all of these rules because the only way they could recommend a disbarment was by enforcing that stipulation where I supposedly admitted to all of these terrible things, even though I was certainly on record as being opposed to it very shortly afterwards. And that was the only way to justify what they eventually were going to recommend to the California Supreme Court. And I realized they do put the cart before the horse that way, that once you are targeted by the state bar court, by the prosecutors, it's almost pointless to bring up rules and cases in your favor. For example, there's one case law, I don't remember the exact words, but supposedly it's still good law. And what it says is that the procedures in lawyer discipline cases have to be fair. And I cited that case to the review department. It made no difference to them. They didn't even talk about that case. And I brought it up again to the California Supreme Court in my petition. They didn't care. Review denied. I also wanted the state bar prosecutors to take out 3 ridiculous charges. I said, okay, I'll take the discipline that you want. Just take out the nonsense in addition to giving a more balanced picture. One of the charges, for example, that they had made up. Nobody complained about it to them. The clients hadn't complained. The judge hadn't complained. It's just something that the state bar, after they decided to prosecute me, they just went digging through and dug up everything they could that would seem the slightest bit suspicious to them, or at least put me in the worst possible light. One of the charges was that in a pleading in the Smith case to the family court, the state bar accused me of lying to the family court judge by me allegedly saying that I had paid every single debt in the Smith case. Well, I pointed out to them that the very next sentence in that pleading asks the judge to make a decision about an unpaid debt. I couldn't have been telling the judge that I had paid all the debts if I'm asking about an unpaid debt, because that's what we needed a ruling on. How are we going to handle this last, not the last unpaid debt, but how are we going to handle this last disputed debt? And also I pointed out the fact that lawyers keep ledgers. They keep trust account ledgers for their clients, an individual ledger for each client, putting the amount that they received in trust and then all the payments that were made in trust. Payments made to creditors or whoever or to the parties. I have never been accused of making a false payment entry on a ledger. And these are ledgers that go out to the clients, that go out to the opposing party or their lawyer. And they still wouldn't drop it. Then the review department did something very insidious with that really demonstrated to me how much of a unity of mind the review department really has with the prosecutor's office. They pretend at independence. They will always put in a little thing that is a little bit different than what the prosecutor says or even what the trial judge says. This is kind of a pretend independence, but they truly don't. The unity of mind is really startling, because in that allegation about lying to the judge, they paraphrased what I had written. They paraphrased it with a subtle nuance to make it sound like I had written what the prosecutors had accused me of. They didn't quote the sentence. They didn't actually quote from it. They paraphrased it. And it was in a way that was subtly against me that made it sound like I had done what the prosecutors had accused me of. And that was really shocking to me. And this is the kind of thing that if a lawyer has not dealt with the state bar court system, if they have just been out in practice in the superior courts or the federal courts, they're not used to judges doing this kind of thing. And it happens in the state bar court. And for most people, it's just unbelievable if you tell them. I would never have believed somebody telling me the things that I'm telling you now in the days when I was just out there practicing in the family courts. It was just inconceivable to me that any kind of justice system like that exists in the state of California. The other allegation was that I had lied to creditors of some of the parties when I wrote saying that I had funds in trust waiting to be paid. They say, no, well, you didn't have enough funds in the county bank accounts to make those payments, so therefore you must have been lying to these creditors when you wrote that you had the money in trust. And I pointed out, well, I didn't say I had the money at county bank. I didn't write county bank in these letters. I just said I had the money in trust. And you are admitting that I had other funds, and you recognize that all the trust payments were made, including to those creditors. As soon as we settled the cases, sure, I immediately paid them. The funds were there. They simply were not at county bank. And they said, well, since you were supposed to have kept them at county bank, and they kept going on and on, I wasn't supposed to have taken it out of county bank, therefore you were guilty of misappropriation, and because you misappropriated, therefore you were lying to these people when you said you had the money in trust because it wasn't at county bank. It was a circular logic that I kept fighting with, and it was very, very difficult to deal with that. The third charge was in regard to 3 checks that I had written out of the state bar account. They were written in sequence, and in the memo section, I had put the name of the client. It wasn't Smith, it was the other case. I'll call that other case Jones. Again, not the real name. I had written Jones on all 3 memo sections, and yet those checks had nothing to do with the Jones case. So I was accused of, basically lying on the checks, trying to attribute these checks to Jones. And I pointed out, well, wait a minute. First of all, my father was 2 days away from dying when I wrote those checks. I had just spoken to him just a few days before. He was living in Reno. I was in Modesto. He sounded really bad. He was in hospice care. The only thing I could think about was just getting to Reno and visiting him. It was during the week. And in fact, my secretary, Lori, could tell how distraught I was. And she came to me and she said, no, Tor, just go to Reno. I'll reschedule your appointments. You don't have any hearings for the rest of the week. Just go see your father. You need to go see your father. I was in such a fog, and my mind was, all I could think about was this dilemma of, I had so much to do. And so I thought I'd wait just a few more days and wait till Saturday so I could just leave for Reno on Saturday and go see him. And that's when I wrote those checks. And I pointed out, and he died just before I could get there. And I so wish I had just made that trip like Lori had told me I should do. And I pointed out again that for that client as well, I kept a client trust ledger. I didn't write those anywhere on those trust ledgers ever. I never said that those were payments on behalf of that client. They were just raw mistakes. The irony in this is that when the review department issued its opinion, the 3 judges did give me credit for the distress that I was going through. They called it a mitigating factor, and they didn't give a lot of weight to it, but they gave some weight to it, which even Judge Miles wouldn't do, and even the state bar prosecutors wouldn't give me credit for. But this review department did. So that they wrote that how the distress of the deaths of these 2 family members was a factor. But then, here was a concrete example of exactly how the distress did cause me to do something wrong, and they wouldn't give me credit for it. It became it just was, okay, no, you put this false statement on these checks, and therefore you are guilty of moral turpitude. So they gave me the credit in the abstract, but they wouldn't give me credit when they were presented with concrete examples. One of the problems that I had was the state bar waited 4 years to file the disciplinary charges against me. From the date that I received the first inquiry letter where they were expressing concerns about some of these things, until the date that they actually filed formal charges, almost exactly 4 years had passed. During that time, I lost witnesses. One of them was the family law judge to whom I had allegedly made a false statement, who could have testified that no, he did not feel misled by anything that I had said. But, 4 years, actually 5 years by the time we got to trial had already passed, and he was a very busy family law judge. His clerk told me he just couldn't remember anything about that one hearing, which was only like 10 minutes long. The other one was the attorney for the woman who had complained about me, and he couldn't remember the case either. And meanwhile, he had given up his law practice. He had gone to live in the wilds of middle California, I should say. And then, a couple of people had moved, including a client who had information. He had moved. And then one of my secretaries couldn't be found. So this is really very unfair that the State Bar has given itself 5 years to file disciplinary charges. Even in civil court, let's say in a wrongful death case, the statute of limitations is only 2 years. And for those very reasons, people move, their memories fade. So even in something as serious as a wrongful death case, you only get 2 years to file your charges, or that is your civil complaint. But in state bar court, they give themselves up to 5 years. And in my case, they used 4 years of that. I hate to say this because I have never said this about any judge, about any courtroom that I had ever practiced in the Superior Court. I have never even thought this about any judge. And that is that what Judge Miles and what the 3 review department judges operated fit the definition of a kangaroo court. That's a very insulting thing to say about a judge. It's a very insulting thing to say about a courtroom. But if you look at the definition, I truly believe that that is an apt description of what they're running in the State Bar. The problem with the State Bar system is that there's this enormous Damocles sword that's hanging over the heads of the prosecutors, the judges, and the people who are being accused. If the judges and the prosecutors don't produce enough disciplined lawyers every year, if there aren't enough disbarments, in other words, if they're not showing that they're being quote-unquote tough on bad lawyers to the satisfaction of the legislature, there is the threat that they will have the bar dues bill cut or not approved. The same thing can happen with a governor's veto, similar to what happened with Pete Wilson when pretty much the State Bar was just totally shut down. People lose their jobs. And that pressure is on from the legislature. That sword is rattled by the legislature every now and again. So it's always there. It's always hanging as a sword over the judges and the prosecutors. The Damocles sword over the heads of the accused lawyers is also financial. It's like you have the potential to be charged with very, very high fees in cost assessments if you don't quickly give in and sign something. You cannot have a justice system like that. You cannot get justice where that kind of threat hangs over judges, where that kind of threat hangs over the people who are being accused. You're going to get false confessions. You're going to get railroading. The most important thing about the cost assessment rule is to understand that it doesn't do what they pretend it's supposed to do. It's supposed to deter misconduct by lawyers. It's supposed to be another one of those deterrents. Like, okay, not only are you going to get disciplined and maybe suspended and not be able to practice law for a while, but you're also going to have to pay the State Bar for the cost of prosecuting you. That's not what it does. You are paying them for cost assessments for justice. You're just paying them a fee, a set fee according to a scale to participate in their justice system. That's all it boils down to. The only thing that you are deterred from by this system as an accused lawyer is you are deterred from seeking justice in the State Bar Court. That is a deterrent against justice. One thing I noticed that the State Bar Court prosecutors like to do, and it seems like most of the State Bar judges go along with it, is they like to inflame the charges and the language against the accused lawyer to make them look really bad and really sinister. For example, in my case, they used omission. They just omitted important facts like how the trust funds were paid and all that to give this wrong impression. So that was basically inflaming the reader through omission of facts. But they also like to use loaded language. And the words that they love to use the most in that regard are the words willful and willfully. They'll say, this lawyer willfully did this, and this lawyer willfully violated this rule, and so on and so on. And they did that with me in regard to, for example, Rule 4-100A. They say that I had willfully violated this rule. The thing is, at the time, I had never heard of Rule 4-100A. But when you say that a person willfully violated a rule or a law, it implies that they knew the law, but they still went ahead and violated it anyway. See, when the public reads these inflamed, exaggerated accounts of what a lawyer did that are made to make the lawyer look as sinister as possible, it gives a worse impression of the overall profession to the public. It makes lawyers seem worse than they are as a whole, because these individual cases are all made to seem worse through inflammatory language or through these coerced confessions or whatever. The State Bar is harming the profession by doing this. It's contributing, I believe, to lawyer bashing when it does this, as it keeps cranking out all of these exaggerated findings and charges, and it keeps coercing lawyers into signing these confessions that are not correct. It makes the whole profession as a whole seem worse. This doesn't mean that they should sugarcoat when a lawyer does something genuinely bad. I know that some lawyers have done some genuinely bad things for which they deserve discipline or even disbarment. I'm not disputing that. I'm just saying that the purpose of a good justice system, of any court system, is accuracy. There seems to be kind of this game with the State Bar and in the whole system. The game is who can be the biggest badass against bad lawyers. The prosecutors like to play badass, like, okay, here, we'll give you this settlement right now. If you don't sign it exactly the way it is, then we're going to get worse with you if you keep trying to go through the system. And they do that. Then you get the judges who want to play even bigger badass, like Judge Miles. Then you take it to the review department after Judge Miles makes his decision. And then the California Supreme Court also, I found out, also likes to kind of play badass with lawyers, either by just denying review. And I had heard when I had sent in my resignation that the Supreme Court was getting into the habit of denying some of these resignations with charges pending. And that they were not allowing some of them to go through because they thought that with this new rule about the stipulations or whatever, they thought that the charges were too serious to allow the lawyer to, quote, get away with it with a resignation. So they decided they were even going to be bigger badasses than even the prosecutors and the State Bar judges who agreed to recommend a resignation. And that's the thing that a lawyer facing the State Bar is up against. They're up against all these people competing with each other who are going to be against you or deciding your case, who can be the biggest badass against you. I was really struck how my experience with the State Bar system was really reflected in that old Orson Welles movie, The Trial, which was based on the Franz Kafka book by that same title. I felt very much like that character that was played by Anthony Perkins. Initially, when they start their investigation, they won't tell you who complained about you. You're kind of kept in the dark about what's going on.
Obviously a mistake. Something very trivial. But the real question is, who accuses me? Well,
What do you mean?
what authority...
Don't you worry about that, mister.
Once they decide that they're going to go after you, then they really start digging around to make everything look really sinister, even very innocent things.
I'm sorry to disappoint you, but I'm afraid you won't find any subversive literature or pornography. Don't touch those record albums.
What's this thing?
That's my pornograph. My phone...
What's this?
What's what?
A circular line with 4 holes.
Circular.
No, it's not really circular. It's more ovular.
Don't write that down.
Ovular.
For goodness sake.
Why not?
Ovular.
We can't not write it down just because you say we shouldn't.
Ovular isn't even a word.
You deny that there's an ovular shape concealed under this rug?
He denies everything.
Mrs. Grubach's husband was a dentist. Oh, there she is now. Mrs. Grubach? Mrs. Grubach? This was Dr. Grubach's office.
That don't matter. She can't come in here.
The dental chair was screwed to these 4 places in the floor.
If you demonstrate a bad attitude about what they're doing, and if you try to correct their mistakes, they actually use that against you.
None of this is going to show up very well on the record, Mr. Kay.
But if you raise a defense, then it's considered that you lack insight into what you did wrong, and therefore you are more deserving of being punished.
My men say you even tried to stop them from putting this down.
Well, I tried to stop one of them from making a fool of himself. Yes, ovular.
What's that?
Ovular.
There's no such word. Mrs. Grubach's husband was a dentist. Now, what's that got to do with your case?
I never said that it did.
And why mention such a thing?
Simply by way of explaining that ovular shape.
Ovular shape.
You go on solemnly writing it all down?
There has to be a record, doesn't there? But this foolish babbling. It's not going to make much of an impression, I can tell you that, Mr. K. It won't look well at all.
So eventually you get to this trial, this sort of rigged trial, where you can kind of tell it's against you. And there's this sense that there's this whole world attached to it that favors what's going on. You're not just talking to the judges in the state bar, but there's a world out there that's supporting what they're doing, and they're just kind of going along with it. You can say what you want, you can protest what you want, but they're not listening.
What's happening to me is of no great importance, but I think it is representative of what's happening to a great many other people as well.
Well, what eventually happened to me, when I finally got very deeply into it, I actually started getting this morbid fascination. I said, it really can't be this bad. At some point, there has to be some relief.
And I only came here because I wanted to see if the inside of this famous legal system was as loathsome as I guessed it was. And now I'm too depressed to want to see anything more.
So yeah, when I found out that it really was as bad as it seemed to be at first, and in fact it kept getting worse, it kept getting more and more disillusioning as I went on. In other words, when I saw Judge Miles do the things that he did, and especially when I saw the review department, which is supposed to be the haven, the safe haven, where if there are mistakes below, if there's injustice below, the review department really is there to catch all of that. And to see them actually perpetuate it and make it worse was very, very disillusioning. And so you get to the point where you just want out.
You're going already, but you have hardly seen anything yet.
I don't want to. I just want to get out of here.
But even getting out, they make it very complicated. They make it very difficult now to get out.
You keep to the right, through that passage, and then you go to the second corner, and then left along the lobby to the fourth.
So finally, my reaction was you just kind of give in to this whole process. You realize you can't change it. It's going to go on the way it's going to go on. It's sort of like the movie in the sense that when the state bar performs its execution, it's done in the state bar court. So when you go into the state bar court, it has this deathly feeling to it. There are no windows. There are very few people. It feels like a mausoleum when you're in there. And it feels very isolated from the world. It feels like you've been taken to this world that's very separated from the world that you've been used to. The state bar court is nothing like the busy courtrooms that lawyers are used to in the superior courts of the federal courts. It's nothing like that at all. It's this very claustrophobic kind of place, and that's where your execution takes place.